California's AB 8, what it means for hemp, bans, deadlines, and new rules. Hey, I'm Morgan Davis. I'm a health and wellness attorney based in Raleigh, North Carolina. Let's talk about how to keep your business protected and thriving. California's had a war on hemp for many years now, as we've been talking about, and they seem to have finally settled the case with the passage of AB 8. AB 8, titled Industrial Hemp, is a comprehensive stitching together of the current hemp framework in the state of California with the regulated cannabis market, and closes the door on the availability of hemp products outside of the regulated cannabis market almost pretty completely for California. The law is effective now, but most of the enforcement and phasing in takes place over the next 24 months. So it will overall look like a variety of different agencies in the state of California adopting regulations to address the overall desire to make sure that hemp and all hemp products in the state of California go through the regulated cannabis market. Why did this happen? The concern and the rhetoric that's been going on publicly in California for years is that the intoxicating hemp market is way out of control, tons of synthetics, kids are getting a hold of unlawful products, dangerous products, the same rhetoric we hear across the country from lots of lawmakers. The underlying understanding is that California is one of the first markets where regulated cannabis has a very big stronghold, and they're fighting tooth and nail to hold on to that, because they have to fight desperately against the illicit market, which still exists and is thriving in the state of California, which they haven't been able to do a whole lot about. So they're going after the one that they can do something about, which is the legal hemp market, because it's out in the open and they can legislate against that. And that's what's happened. There's no carve out for anything. The only hemp products that will not be subject to these regulations are those that are being sold out of the state of California, and those that are non-intoxicating. Non-intoxicating in this instance for the state of California will mean products that have not even a trace of THC. So you're thinking CBD isolate products, mostly topicals, they will not have to be sold within the cannabis market. What are the biggest changes we see? One, a companion bill to this plus AB 8 prevents the online sale of products, of hemp products, to California residents pretty completely, and requires that anyone selling into the state of California have to register with perhaps the CDPH, maybe also the tax department, maybe some others, but certainly the CDPH or the California Department of Public Health. So if you plan to continue to sell products into the state of California, you will need to register and comply with California's requirements. You will also have to potentially go through the regulated market depending on your product. Additionally, for synthetics. So synthetics have been banned in the state of California for quite a while, but this makes it even clearer that any converted cannabinoid is also a synthetic under California law. So oftentimes we understand that CBD is converted to Delta 9 or Delta 8 or many other types of cannabinoids, and then those conversions are used to manufacture products. California is taking the stance that that conversion in of itself is illegal and is defined as a synthetic and is completely banned. Depending on where you are in the supply chain, here's what it changes for you. If you're a manufacturer in or out of the state of California, plan on making significant changes to your manufacturing protocols, having to provide a lot more documentation about your products themselves, comply with packaging and labeling requirements, testing requirements, and registration of your product in state. For distributors, expect your channels of where you can sell products to be limited. You will also have to obtain licensing and potentially register the products yourself if they're not registered by the manufacturer. If you are a retailer, again, everything's going to get shoehorned into the regulated cannabis space. You're probably going to have to obtain a license from the Cannabis Control Board in California. If you are a licensed retailer, meaning you're already in the cannabis space, then this opens up opportunity for you in terms of the types of products you can start carrying in your store. Whether or not you choose to, we'll see how the market shapes up, but you will have a lot more products available to you that have pivoted from the hemp space. What to do now? The implementation of these regulations, as I stated before, will take the next 2 years, so it's not immediate. Some of it's coming into effect January 1, 2026. Most of it doesn't come into effect until January 1, 2028. The first thing to do is understand what's happening, especially if you're in California, and make a decision as to whether or not you're going to stay in California or you're going to exit the state entirely. The next thing to decide is if you're staying, start looking at what you're offering and what you're wanting to continue to be able to offer and determine what channels that's going to be possible in. Are you going to have to put everything you're making through the regulated market? What's that going to look like for you in terms of taxation and the lift from a compliance perspective? Or are you going to have some products that stay out of the regulated market? Next, start thinking about paying attention to the rules as they come out, because the next 2 years will really determine what it looks like. Each agency is going to have to promulgate its own rules around this industry. So that's the California Department of Tax and Firearms, that's the California Department of Public Health, that's the Department of Agriculture, and it's the Cannabis Control Board. All of them will be creating rules. It's a lot to stay on top of, so give us a call and we'd love to help find you the answers you need. Beyond that, start thinking about what you want to do in the next 2 years. So if you're going to pivot into the regulated space, are you doing that as a wholesaler? Are you doing that as a retailer? Are you going to stay a manufacturer? All of those decisions will help you chart out the best course for your business and whether or not it's time to pivot out of California entirely. Bottom line, in contradiction to what a lot of the media says, California did not just ban Delta 8. They have successfully at this point shut the door on the legal hemp industry in the state of California and have ushered it almost all the way into the regulated market. Now we will all watch and see whether or not the regulated market will grind hemp products to a pulp and continue to sort of corner off the market for themselves, or whether or not they will invite in the hemp industry and its products and enjoy a larger availability of options. Stay tuned. The next 2 years is going to really change the face of hemp in California.